kids, I didn't see you there. Well, let me tell you a little bit of story today. Your rights with law enforcement. Your first right is you have the right to remain silent. Anything you will say could be used against you in court. Second, if you don't have an attorney, one could be appointed for you.
Does an officer have to have if they want to search your house?
A warrant.
Does a police officer have to have if they want to search your house?
A warrant. Yay.
When you're arrested, is it mandatory for you to answer all the questions that the police ask you?
No.
What right ensures your protection against self-incrimination?
I don't know.
It is the 5th.
Okay, what must a law enforcement officer have if they want to search your house?
A warrant or probable cause.
What amendment ensures your protection of self-incrimination?
You know what? I'm sad to say that I don't know.
So what amendment ensures your protection against self-incrimination? Fifth Amendment.
Fifth, I was guessing fourth. That's something else.
In a real life situation, this is what you shouldn't do.
Bad boys, what you want, what you want, what you gonna do when Chevy John don't come for you?
Here we are with the El Dorado County Sheriff's Station. Flipping to Yui right now. Here with my partner Chime.
We spot a white Acura TL swerving down the road. We're coming in close, about to bust this dude.
We're just gonna follow up on his tail to see what he's doing. Yeah, he's driving erratically right now. As you can see, he's swerving, so I think we're just gonna start with the traffic stop after we see what he's doing. Alright, so we attempted the traffic stop right now. We're gonna get out of the vehicle. Third time this week, man. Third time this week. We're just gonna go up to the suspect and see what's up right now. Gonna ask him what's going on. Seems to be drinking as we come up.
How's it going, officer?
Hey, have you been drinking tonight, my friend? You
No,
were
I have not.
You're driving
What's
pretty
in that water
erratically.
bottle? Can I see your water bottle?
It's just water.
Let me see your water bottle.
I would
Smells
prefer
like
if you
alcohol.
didn't do
Let me
that.
see that. Alright, why don't you go ahead and step out of the car, sir? This is evidence right here.
This is bogus, man. I haven't been drinking at all.
Beg to differ. So, since you were swerving, my friend, we're gonna have to breathalyze you.
No, I don't
We
believe
have
in
to
this.
perform some tests.
You
Hey, where
guys don't
going?
have reason.
Alright, come on, car, we got it running. We're doing it right now. He's running. We're gonna tack him to the ground. We have the right to remain silent.
This was a bad example because, one, you shouldn't drink and drive, and two, when a cop has probable cause, he is allowed to search you and your car. And next, here's a good example.
Rapidly.
Yeah, what is he doing, man? We're just gonna go ahead and attempt a traffic stop right now. Just gonna pull him over. Go talk to him, see what's up. A lot of young kids out in EDH. You really never know, man. Hey, driver, step out the car for me, please. Step out the car for me, please.
Did I do anything wrong?
You seem to be swerving, my friend. You been drinking tonight?
No, I have not, sir.
Can you please step out of your car so we can do some tests?
Step out the
All
car.
right. I guess
Step out the
I'd
car.
like to.
Come on. Turn the car off before you run on me. Every day, man. Every day.
Okay, can you walk in a straight line for us?
Just before.
The First Amendment protects your right to free speech. However, anything you say can and will be used against you in a court of law. In Caleb's situation, you should probably remain silent to avoid self-incrimination. Your Fourth Amendment protects you against unlawful searches and seizures. Therefore, in Caleb's case, you shouldn't have ran and just allowed the administration of a blood alcohol content test.
Survey results show that 31% of defendants and 36% of undergraduates wrongly believe that their silence during arrest could be used as incriminating evidence at trials.
So, in Maples, Ohio, police officers forcibly entered Mapes' home in search of a bombing suspect. The officers failed to produce a valid search warrant and denied Mape contact with her attorney. The officers did discover illegal pornography in her home, for which she was charged and convicted. The Supreme Court ruled that illegally obtained evidence is not admissible in state courts, and that violates the Fourth Amendment right against unreasonable searches and seizures and could not be properly enforced as long as illegally obtained evidence continued to be presented in courts.
In the Supreme Court case Riley v. California, Riley was stopped for a traffic violation which eventually led to his arrest on weapons charges. An officer searching Riley prior to the arrest seized a cell phone from Riley's pants pocket. The officer assessed information on the phone and noticed the repeated use of a term associated with a street gang. Detectives specializing in gangs later examined the phone's digital content. On photographs and videos that the detective found, the state charged Riley in connection with a shooting that had occurred a few weeks earlier. Riley moved to suppress all evidence that the police had obtained from his cell phone. The trial court denied the motion and Riley was convicted.